Okay, good morning. Thank you all for your patience, everyone who's joined the webinar. Apologies for our troubleshooting. Welcome, thank you for being here today for this webinar. My name is Natalie Petrucci. I am the Pro Bono Coordinating Staff Attorney with the Rocky Mountain Immigrant Advocacy Network's Children's Program. And I am honored today to be joined in collaboration with two colleagues from two fantastic immigrant serving organizations here in Colorado. So today presenting in collaboration, we have from the Colorado Asylum Center, the Executive Director and amazing lawyer and advocate, Christina Brown. And we also have from the International Rescue Committee of Denver, the Legal Director of the Survivors of Torture Program, Elise Anglin. And I'm also pleased to co-present with my colleague from Romaine, Colleen Calgill. She is the Pro Bono Coordinating Staff Attorney with our detention program. Before we dive into the topic at hand, which is the war on asylum, I just want to give a couple of updates. First, we are still in the process of trying to obtain CLE credit for this webinar. If you registered today, we do have your email, so we are happy to follow up with you once we get more information so that you can log your credits for being here today. And hopefully, even if that doesn't come through shortly, you're still obtaining a lot of great information today and happy to be participating, but we are hopeful that you can get CLE credits for your participation. And second, we have a whole lot to cover this morning, and that will really be scratching the surface of some of the topics that we would like to cover more in depth, but we have about an hour and a half. So we are going to try to save questions for the end. If you do have a question about a particular topic or for a particular presenter, we ask that you please use the Q&A function, which is at the bottom of the screen. One of our fellow presenters and moderators are going to be keeping track of those. And then at the end, we have about 20 minutes for questions. So please feel free to write your question there or save it till the very end. Okay, so our topic today is the war on asylum. And as I'm sure many of you are well aware, this current administration has made sweeping changes to US asylum and refugee policy that have led to devastating consequences for the lawful rights of people seeking protection in this country. President Trump initiated his 2016 presidential campaign by vowing to shut down different forms of immigration, to build a wall, to block citizens of Muslim majority countries at our border, and used racialized rhetoric and racialized tropes to really instill fervor in his base that ultimately escalated his candidacy. And then in the days since taking office, or in the early days of taking office, he made very large sweeping changes to immigration law through a series of executive actions that arguably really stretched the power of his office, but really laid out a plan for his vision of how he wanted to see drastic changes to both interior enforcement in our country as well as enforcement at our border. And these were kind of unprecedented changes that have been enacted. And since those early days, we've seen this vision kind of being played out. Over time, we're seeing these very targeted policies chip away at the rights of asylum seekers and refugees in our country, and ultimately affecting some of the most vulnerable immigrants that come to the United States. Families, children, people who are medically vulnerable, asylum seekers who are fleeing torture and severe persecution in their countries of origin. All of this collectively is a war on asylum. So no matter who wins the election this November, it's important to understand that these policies, this systematic oppression of human beings and refugees and asylum seekers, and the handpicked adjudicators who are hearing these claims at every level, both the agency level and the immigration judge level and the appellate level, these systems and people are going to be with us for a long time. And so because much of this war on asylum has been waged in the shadows of bureaucracies or at the very remote edges of our borders and even the borders of other countries, which we'll talk about today, we really want to bring some of these attacks to light in hopes that you will leave this webinar more educated about what is going on and also be empowered to join us in our fight to defend the rights of asylum seekers. So with that, I'm going to turn it over to Colleen, and we're going to get started with the presentation.
Great. Well, thank you so much, Natalie, for that Introduction. As Natalie kind of touched upon, we divided these topics into two main areas, starting with attacks on the border or before individuals enter the US, and then the second half will be attacks within the interior. And we've also tried to organize them chronologically as well. So the first thing that we're going to talk about is family separation. This is probably something that many of you have heard of or at least familiar with. This policy was announced by then Attorney General Jeff Sessions in April 2018. He announced this policy through a memo, and this policy was known as the zero tolerance policy. So through this policy, the administration sought to prosecute any individual who entered the US illegally. They sought to charge them with the criminal charge of illegal entry or reentry. Through the policy memo and later documents that were released, we know that the administration clearly considered the effect that this policy may have on families. In the policy memo, there was discussion about whether this policy should be implemented just against single adults or if it should also be implemented against any adults, so including adults that enter with a child. The administration chose to implement it against any individual, so including parents who enter with a child. And their stated reason for doing so was that they believed if it was only implemented against single adults, that could create a sort of perverse incentive for individuals to present themselves as families, falsely doing so, even though we know that that is clearly debunked and there's no factual basis or reason for believing that that would actually happen. So I say that just to kind of emphasize that this family separation policy was clearly something that the administration considered. It wasn't something that happened, by accident or without their knowledge. It was part of the calculus of implementing this zero tolerance policy. So in terms of how it actually laid out, in 2018, when individuals entered the US legally, if they were in a family unit, the parent would be transferred to Department of Justice for prosecution for the illegal entry or reentry charge, and the child would be transferred to a different custody center. Oftentimes it could be hundreds of thousands of miles, oftentimes in a different state than their parent. They would be cut off from communication with the parent, or at least have very strained means of communication. Through court documents and other sources, we know that at least 2,600 children were separated from their parents, and that roughly 40% of those who were separated were under the age of 10. And many people believe that the numbers are actually much higher. And that's because the government, when they implemented this policy, they didn't have adequate means of keeping track of who was entering as a family and keeping track of the connection between parent and child. So we feel that a lot of that data likely wasn't captured, and that it's possible that parents entered the US and weren't notified to be family units. Another thing is when parents and children were separated, this also resulted in some cases in the parents being deported or removed while their child was still here in the US, and having no way to notify the child or have communication with them before that was carried out. We know that the median length of detention was about 154 days, so about 5 months of parents being separated from their children. And oftentimes, in many cases, it was actually much higher, in some cases even a year or more of separation between parent and child. We've put this topic in the border attack section because the underlying goal of this policy was to deter individuals from seeking asylum in the US. So the administration thought that by charging individuals with criminal prosecution, and then also by separating parents from their children, that this would mean that individuals may not want to seek asylum in the US, which is really horrific, because we know that the right to seek asylum is something that's protected both by US law and international law. So the fact that the administration was trying to disincentivize people from seeking their rights and trying to avail themselves of these protections is really horrific, in addition to, the cruel and inhumane way that they decided to carry it out. In terms of the current status, in June 2018, so after this policy was subject to increased media attention and advocacy efforts, the administration announced in an executive order that they were purporting to end this zero tolerance policy. The policy was also enjoined by a court, and the courts ordered the reunification of parents and their children. However, we know that even after that happened, that more than 900 children continue to be separated from their parents and children that year. Sometimes the stated policy or stated reason was for criminal prosecution, but oftentimes the administration has also cited other vague or unsubstantiated reasons. So sometimes saying it's because of alleged criminal history of one of the parents or even medical issues. So this is something that we still continue to see to this day, and is a very clear attack on the individual's right to seek asylum. So with that, I'm going to hand it over to Christina to talk about the next few issues.
Okay. All right. So family separation, while one of the more well-known deterrence policies put into place by the Trump administration, is certainly not the only one. In 2018, around the fall of 2018, but there were anecdotal reports of it happening earlier in the summer, CBP started a process known as metering to make it more difficult to seek asylum in the United States. And so what that means is that asylum seekers, once they approached the border, were turned away and told that they had to wait in line, basically, to seek asylum. And so there were lists put together that were run by asylum seekers themselves, who would guard the list and add people to the list and monitor the list each day. The US government and the Mexican government denied any involvement with the list. However, it's very clear that was untrue. A lie, considering CBP would come to Mexican immigration every day and tell them which numbers from the list they would take that day, and then those people would be allowed to present and go through a CFI, or a credible fear interview process, or a reasonable fear interview process. There were a lot of problems with metering, one being it's super illegal, but the other being that it was really enforced very haphazardly as well. There were multiple reports that UACs were exempt from metering. However, they weren't being allowed to present to request protection in the United States under the TVPRA. They were just being turned away by CBP officials. Cartels were alleged to have been reviewing lists for people that they were looking for within Mexico, and they would then be able to determine which city those people were in. And then family members who came after, or who, used one of their last names on the list instead of both last names, were being prevented from presenting for asylum when the numbers were called, which resulted in additional family separation during the metering process, but also resulted in people just being denied the opportunity to request asylum because the people running the list were arbitrarily enforcing who could and who couldn't get on the list. So lots of problems. There were also issues of extortion to put names on the list, and this was happening across the southern border and into South Texas. People were waiting more than 6 months in some cases in Mexico to just be able to start the threshold process for requesting asylum in the United States. This practice has been challenged. The lawsuit is still pending. However, as we're going to discuss a little later in my presentation today, very few people are actually getting through Mexico to present at the US border now, and those who are being expelled for different reasons. So in effect, we haven't heard a lot about long-term metering waits at this point. It's now transitioned into long MPP waits, which we're going to talk about next. So the Migrant Protection Protocols, when metering wasn't sufficient and family separation wasn't sufficient to deter people from seeking asylum, the administration implemented what's called the Migrant Protection Protocols, otherwise known as Remain in Mexico, a false, a misnomer at best, considering that it actually results in persecution and harm to people forced to wait in Mexico to request asylum in the United States. It was started January 24th of 2019 and basically forces people to wait in Mexico to go through the asylum process instead of being allowed to seek asylum within the interior of the United States. So what it looks like is once people were called to present themselves from the metering list, they were then processed by CBP, given a hearing notice to come back and present at the border for a master calendar hearing in immigration court, and then sent back into the border cities along the southern border. As of December 2019, there are more than 60,000 MPP cases, more than 60,000 people waiting in Mexico border cities to request asylum. Some of those cases have started. The in absentia rates in the MPP program are very high. We've heard a lot of reports of people being kidnapped, disappeared, raped, extorted. It's basically impossible to prepare your asylum case while stuck in a tent or sleeping on the street or sleeping in a park in a Mexican border town, simultaneously attempting to evade cartel violence and violence of Mexican law enforcement officials who actually have been the perpetrators of a lot of violence against asylum seekers stuck in Mexico. Also, as of December 2019, only 0.1% of MPP cases have been approved. I want you to really think about that number. While asylum rate approval rates have plummeted under the Trump administration, literally if you go to the DOJ website and you look at asylum statistics, by 2016 the line just goes straight down to 20%. So still 20% of people nationwide are winning asylum claims in the interior of the United States, and 0.1% of the cases that are heard are approved at the border. It's extremely problematic. Made more problematic now with the COVID issues that we're facing and COVID expulsion, which Elise is going to talk about. But basically, the administration is now using COVID as an excuse to indefinitely delay asylum hearings, which, though unfair, are still a process that people hold on to hope for. They want their day in court. They want a day to ask for protection in the United States. Recently, it was announced that hearings in MPP are going to be extended, are going to be canceled through most of June. And many people, including myself, believe that that will continue to be extended with the hopes of just completely deterring people from pursuing their asylum cases in the MPP process and abandoning and returning home. So MPP has been really highly problematic. In addition to the process itself, there's also a lot of fraudulent and illegal activity that goes on within the executive branch to implement MPP, including the falsification of court documents by immigration judges who work for the Department of Justice, to send people back to Mexico after they have been heard in court while waiting for their appeal period to expire. Also, there are a lot of service issues with MPP. So now that all of these hearings are being canceled or postponed, moved down the road, there's no way to serve people who are waiting in Mexico because, first of all, the government doesn't have people to serve people in Mexico. But second of all, there are no known addresses. And so there's no way to get this information to people. They basically have to come to the port of entry, assuming everything will go forward as promised, and then be told that they'll be waiting multiple more months if they get a chance to come in at all. So many MPP problems, but that still wasn't enough. So in June 2019, Mexico agreed to basically make it impossible to reach the southern border of the United States due to a lot of pressure being put on them from the United States government. But right now, what we're seeing is that on the border of Mexico and Guatemala, the Mexican National Guard, which was created to respond to the immigration issues, migrants traveling through Mexico to reach the U.S. southern border, they're now preventing people from going through at all. So we've seen thousands of people basically detained by the National Guard in southern Mexico, people who would otherwise really have strong cases in the United States. In addition to many Central American families, we're seeing many people, asylum seekers from African nations, who generally have very strong claims that are likely to be approved if they reach the US, being prevented from transiting through Mexico to reach the US border. And so they're being denied asylum. They're also facing a lot of abuse from Mexican officials. Many are of African descent, and so they face a lot of discrimination and abuse on the basis of race, in addition to being migrants in Mexico and being targeted for that reason. I can go to the next slide. But people are still approaching the United States to seek asylum. And of course, that's because the things they are fleeing are much worse than what they would experience under the Trump administration here. So the Trump administration expanded in 2019 and 2020 two programs designed to basically expel people faster who were still making it to the border to seek asylum. The prompt asylum claim review is for anyone not from Mexico seeking asylum in the United States, and the humanitarian asylum review process, HARP, is for anyone from Mexico seeking asylum in the United States. So what happens with this is if someone approaches, wants to request asylum, is not amenable to MPP, you know, if they, I mean, most people are not removed from MPP now, but you know, if they have disabilities or if they're targeted in Mexico for some reason and they can prove it to the satisfaction of a CBP officer or an asylum officer, they may get through to some of these processes. Basically, they're held in CBP custody. They're given one phone call, which they can either call their family or they can try to reach a legal representative and talk to that person one time before they have a credible fear interview. And so the reason this is really important is that in CBP custody, people don't have access to counsel. They don't have a right to counsel. So they're not allowed to have someone represent them in these proceedings. They're literally allowed to consult with an attorney if they have an attorney's number already by the time they're in CBP custody, before they're put into this very, very adversarial interview now, an interview that's supposed to be non-adversarial, with a CBP officer or an asylum officer. So this could include individuals who have special circumstances in Mexico, asylum seekers from countries where Spanish isn't the primary language, other than Brazil, or individuals who are more likely than not to be persecuted in Mexico who are going through this process. So highly problematic, another attack on access to counsel and due process, and preventing a lot of people from passing this threshold screening, which most people used to pass because the threshold is very low to pass credible fear interview. Now we're seeing a lot of people denied and just summarily returned for not passing these interviews without access to counsel and without really any oversight, since there's no access to counsel. And then, as if that weren't enough, we're now dealing with asylum cooperative agreements. Started in early 2019. It took a while to get details finalized and to get these agreements implemented. Some are still not finished, but basically agreements between the United States and the Northern Triangle countries of Guatemala, Honduras, and El Salvador, where if people approach the US border and they ask for asylum, the United States can then transfer them to one of these countries to request asylum there. A farce of an extraordinary magnitude, considering these Northern Triangle countries, first of all, do not have capacity to accept and process asylum seekers. And the governments of these countries have stated they don't have the capacity. Guatemala has less than 20 asylum officers, and El Salvador's president has said they don't have an asylum system in place that can process these people. But additionally, all of the conditions that are forcing people to flee one of these Central American countries are present in the other Central American countries. So gender-based violence, gang-based violence, the same people and groups that people are fleeing in Guatemala exist in Honduras and El Salvador and have the capacity to track them to those places. They're being held in camps in very far off places outside of the city in Guatemala, and Honduras was recently finalized and will begin accepting asylum seekers. And so the big issue at the beginning of this was there was no agreement in place as to who would care for asylum seekers returned to Central American countries, who would feed them, who would clothe them, who would make sure that there was security to prevent people from attacking them. And the US basically said, not our problem, and figure it out to countries that can't even take care of their own citizens. And so a lot of people are now just being summarily flown down to Guatemala or now Honduras instead of being allowed to process into the United States or being put in MPP or any of those other deterrence programs the Trump administration has put into place. I lost my train of thought there. There was one more important thing I was going to say about that. But in any event, the United States position is, you know, as long as these other countries that they're being sent to have agreed to international conventions protecting refugees, it's fine to send them there. There's no right to claim asylum in a specific place. And so the US government is now also trying to expand this to sending Mexicans who are seeking asylum to Central America to seek asylum instead of allowing them in. From what I know as of now, that has not happened yet, but it has been in discussion for at least the last few months and talked about very widely. It's unclear if Mexico is going to push back in any real way on that plan, or when we might see that begin to happen. And I'm passing it over to Elise to talk about the third country transit ban.
Yeah, so piling on to all of these already just exceptional challenges we're seeing, we have the third country transit ban, or otherwise known as the Asylum Ban 2.0. And so this went into effect July 16th of 2019. And what it does is it bans all refugees who entered the United States from the southern border from receiving asylum if they traveled or transited through a third country on their way to the United States. So there was immediate litigation that attempted to challenge this ban. A lawsuit was brought in the district court from the Northern District of California. But unfortunately, on September 11th of 2019, the Supreme Court determined that the injunction that had been put into place nationwide, should be lifted or should be stayed. So essentially, the regulation now is retroactive back to July of 2019 to affect persons who sought to enter on or after that date, while litigation remains pending. So oral arguments were heard in December of 2019 in the Ninth Circuit Court of Appeals, and the litigation remains ongoing. Nevertheless, this is still affecting thousands of people who are attempting to enter from the southern border. It's not clear, unfortunately, whether this will affect people who were sent back under MPP protocols on or after July 16th, 2019, and remains to be seen. But ultimately what this means is that people who are entering from Mexico without seeking asylum first in Mexico are being designated as essentially like banned and barred from asylum relief despite the merits of their claim. So they now have to seek withholding of removal or protection under the Convention Against Torture. If they, like, these forms of relief carry a much higher burden of proof rather than what one would normally have to prove under asylum. So it means that ultimately countless numbers of people are kept from relief, and rates of success for withholding or CAT protection are extremely low, as previously mentioned. Another thing to keep in mind too with these different forms of relief is that they don't entail the same kind of benefits that asylum does. So somebody who is granted withholding of removal or CAT may still be removed. They're not necessarily guaranteed they stay in the United States, they're not allowed to bring their family members, and they're not allowed to travel outside of the United States. They're granted employment authorization. That's essentially it. And so this is, again, another way in which we're seeing kind of another de facto family separation. So somebody can be granted withholding of removal or CAT, but their family members are no longer able to derive relief under their claim as they would have been with asylum. So they're now having to prove their own independent claims and submit their own independent applications. So someone can be granted while their family members are going to be remaining behind and stuck in Mexico. Seeing this ban, it takes effect in essentially expedited removal proceedings. So someone can be kind of evaluated and then dismissed very quickly, unless they meet one of the 3 exceptions, which are very narrow. So they have to show that they applied for asylum, but they were actually denied, not simply that they just put in an application to kind of say that they applied. They have to go through the process to be denied. They have to show that they are a victim of a severe form of trafficking, or they have to show that they did not pass through any country that's a signatory to the Refugee Convention, Protocol, or the Convention Against Torture. Mexico is a signatory to this, so this last exception is completely toothless. It means nothing. So that's off the table. There is likewise no further guidance as to what a severe form of trafficking means, and how somebody might qualify under that exception. And then finally, as to the first exception, consider that most people are not going to apply for asylum in their country of transit because it's extremely dangerous, as previously alluded to, based upon cartel violence and things like that that are already plaguing people at the border, or because they are not necessarily protected from the forced return to their countries if they apply. It's also incredibly important to understand that there are no exceptions for unaccompanied children under this regulation. And what this ban kind of does is it essentially kind of corrupts things that are already in place for asylum. So it corrupts the firm resettlement agreement, which says that somebody is not eligible for asylum if they have been firmly resettled. And this kind of takes it and extrapolates it way beyond what was intended by the INA. And let's see, it does affect people from all over the world, not simply people from Central America. As Christina was mentioning, it affects people from Sub-Saharan Africa who are coming up through the South, who otherwise have very strong, very legitimate claims for asylum. And we're seeing an increase in people trying to enter from the northern border over the past 3 years, but still many, many people are subjected to this issue. We can go to the next slide. So getting into also the other complicated wrinkle that Christina mentioned earlier is what we're seeing with COVID-19 expulsions. So essentially, if you can kind of get through all of these hurdles, you're now having to deal with asylum in the world of COVID. And essentially what is going on here is that on March 20th of 2020, the CDC issued an order called the Public Health Service Act, 42 US Code 265. It's a fairly loose regulation, which means it's also a very broad kind of order. And it was originally based, it came into play, implemented in 1944, and is being kind of re-earthed now. And it essentially allows for the prohibition of people, of the introduction of persons or property from either Mexico or Canada, if it's in the interest of public health. This stands for a renewable 30-day period. We've already seen it renewed once. It's currently scheduled to go on until May 20th of 2020, but it is highly likely, I would imagine, based on certain reports, things like that, that this will be continued to be renewed and be continued to be used as a weapon in this kind of realm of the war on asylum. It essentially only requires that there is an existence of any communicable disease in the foreign country. So again, very, very broad language that's being used at this time. And essentially it's targeting people who are crossing without valid documents. So again, in practice, it's targeting asylum seekers who are seeking protection without evaluating their fear of return. Again, unaccompanied minors are not exempted from this policy, which violates our obligations under the TVPRA. To avoid being expelled if somebody does have a fear of returning, they have to affirmatively voice it. They're not going to be asked any questions about this fear. They have to affirmatively and spontaneously voice what is determined to be a reasonably believable fear. And this is basically a made-up standard that's being implemented. So we have yet, there's very, very few reports, if any reports, of anyone actually making the standard and determining, being found to have a reasonably believable fear of that their claim is going to happen. Consider that the most recent figures, to kind of extrapolate how preposterous this is, in March, there were 6,400 people expelled at the southern border. And again, this went into place March 20th, so in 10 days, 6,400 people were expelled. In April, 14,000 people were expelled. So we're looking at 20,000 people expelled under this policy, and no one has been able to meet this reasonable belief threshold. So considering, again, how preposterous the standard is, how it's likely to be extended, this is a very, very scary thing to be seeing happening. There is currently the justification that they're allowed to do this because of the worry about congregations and how that can increase and pose a health risk. But again, considering all of the policies that are already in place, that congregating health risk is a result of actions that have been taken by CBP and DHS to keep people in these populated areas. So essentially, they've kind of created the risk and they've created the justification for this. And again, consider too that people are expelled to the nearest border crossing, but we're also seeing, of course, people being expelled to deported, for example, and that's posing its own issues, right? So recently, the health minister of Guatemala came out and said that these deportees from the United States are severely driving up that country's COVID-19 caseload. They reported that 75% of a plane load of people tested positive for the virus. So that's going to put such a huge strain on their already taxed public health systems. For many reasons, this violates our asylum and asylum laws and our international obligations against non-refoulement, as well as, again, it violates our TVPRA obligations. So there's currently no real legal justification being offered for this. There's no legal justification to say that this piece of the code supersedes any other piece of the code that safeguards the rights of asylum seekers. So yeah, we can see, unfortunately, how scary a time this is, even piled onto what's already going on. Yeah. And I think I'm turning back to Colleen.
All right, thanks, Elise. Yeah, so moving to attacks within the interior of the US, the first thing that we're going to talk about is immigration detention. So immigration detention really poses a number of attacks on the asylum system, both related to the conditions of confinement, but also in the ways that detention impedes an individual's access to have a full and fair hearing on their case. So starting more basic, just with what is immigration detention. It is civil, not criminal custody, but yet individuals are often held in prison-like conditions. So because immigration proceedings are civil in nature, that means that immigration custody is civil. However, the conditions are almost exactly the same, and oftentimes individuals are actually held in facilities alongside individuals who are being held in criminal custody. Immigration detention is operated under the authority of the Department of Homeland Security, and specifically within Immigrations and Customs Enforcement, so under ICE. Yet the government often contracts with private prison companies. The GEO Group is one example to run and operate these facilities. So this map here that's on the slide shows first the number of immigration detention centers and where they are located within the US. But then the red dots are facilities that are operated partly or fully on private contracts. And that itself also poses a problem because these private companies are often incentivized by maintaining a certain level of bed space, as they call it, every day. So their objective is not to work with the government to kind of individually determine who should be subject to immigration detention and who shouldn't. Their goal oftentimes is to maintain a certain level of individuals within the facility so that they can continue to meet their contract and achieve those goals. The conditions of confinement pose a number of challenges for individuals in detention. Most obviously, the restricted movement within the facility, the use of restraints when individuals are transferred between court and between different areas within the facility. But also, they pose challenges in regards to access to counsel and achieving a full and fair hearing. And that's because these detention centers are often located very far, sometimes 2, 3, 4, even more hours from any major city. And the further away you get from a major city, oftentimes the further you are from ample legal resources or community support. So here in Colorado, in a way, we're lucky that the facility here is in Aurora, but that is kind of an anomaly in many respects. In many other parts of the country, these facilities are located very far away from major cities. So that also means that the individuals will have less contact with family members or loved ones. Individuals in immigration detention often have limited access to phones. In many places, they have to pay to use the phones, and those fees can be very high. So that also, in addition to not having support while they're being held in custody, oftentimes people need to rely on their family members to be able to gather evidence in their case if they don't have an attorney. So if they don't have that access, it's going to be even harder for them to prepare documents and gather evidence to support their case. And even further on top of that, individuals in immigration detention, the immigration courts are often located within the detention center, and their cases are heard on a more expedited docket than individuals who aren't in immigration custody. So oftentimes, if an individual is applying for asylum and they're in immigration detention, their asylum hearing could be heard within a matter of weeks after they have initially been transferred to the facility. So for someone who's detained, who may not have access to an attorney, who doesn't have access to family to help them prepare their case, the fact that they have to prepare everything on such an expedited docket poses an even greater challenge to really having a full and fair hearing on their case. And then, of course, asylum seekers who are here in the US have often been through traumatic experiences in their home country and on their migration here to the United States. And that's further compounded by the conditions of detention, which often lead to re-traumatization and depression and isolation because of the nature of these conditions. As far as the number of individuals who are held in immigration custody, this has greatly expanded in recent years. In the last 25 years, this number has increased over 9 times. So going back to 1994, about 5,500 individuals were held in immigration custody on any given day. And now currently that number has kind of skyrocketed up to 45,000 people who are held in immigration custody on any given day. Looking specifically here at the facility in Aurora, the pictures here show the Aurora facility. Our facility here has also expanded. Right now it has capacity to hold up to 1,500 individuals. And that includes both men and women. And I'm going to transfer now to COVID-19 and how this has also been posing a greater challenge to immigration detention. So no expert, but we know that COVID-19, that this virus transfers more easily in places where individuals are held in close proximity to each other for prolonged periods of time and where there's poor air quality or low airflow. So that kind of is by definition detention or prison facilities where we have seen already a number of outbreaks in these detention centers. So there are individuals who are held here who are at higher risk of contracting COVID-19 and developing a serious illness. That includes people who are over the age of 55, people who have cancer, prior cancer survivors, individuals with hypertension. Any number of conditions could make someone at high risk to COVID-19, yet they continue to be held in immigration detention where it's impossible to distance from each other, and where the government is not providing adequate equipment. We know that up until a few weeks ago, at most facilities, the government wasn't providing people with anything to protect themselves from the virus. So people weren't being given access to masks or to gloves, even to proper cleaning equipment. Here in Aurora, we've heard from clients that in some cases, individuals are having to share a single tissue between many people to clean their dorms. We know that individuals also have restricted access to medical care. So during these times, it's especially important for people to have the help of an attorney to try to seek release from detention, especially if they're high risk. But really, we feel that anyone at this time is kind of at an urgent need to seek release. And brings me to the last point, that immigration detention, there's no law or case law that gives a strong authority about the length of immigration detention. People can be subject to prolonged detention, and there's no right in many instances for them to have a bond hearing or to seek review of their custody status. So depending on the posture of their case and how they entered the US, many individuals aren't going to be eligible to have a bond hearing. For example, asylum seekers who enter at the border and present themselves at a port of entry, they're not going to be eligible for a bond hearing. They're only going to be eligible to apply for parole, which is a release application that's decided by ICE. So they're going to be asking the individual who's responsible for detaining them to also make a decision about releasing them. So there's no separation there and no real oversight of that process. So all of these things are really compounding an attack on the asylum system here in the interior and making it harder than ever for individuals to really have a fair way to present their cases. Now I think I am going to hand it back to Elise, or no, to Natalie. To Elise.
This is actually going to Christina.
Oh, sorry about that. There we go.
Okay. So assuming, you've entered the United States before all of these roadblocks, or you somehow get through the roadblocks at the southern border, such as MPP, you're now facing a very unfair and expedited system within the United States to ask for asylum in many different jurisdictions. The Family Unit Docket, or FAMU, as it's referred to, was implemented in 2018 with the goal of completing asylum cases for people seeking asylum in family units within 365 days of the date that the NTA was filed in court. This has been a very problematic docket, started in 10 cities across the country, but has since expanded to at least 20 cities across the country, though EOIR still reports statistics from only the initial 10 cities. As you can see from the chart included here, it's very hard to win relief on the family unit docket. There have been 66,746 cases completed as of the end of March. Only 2,361 cases have been approved in the initial 10 cities that began family unit dockets. These dockets present a lot of different challenges. So first is access to counsel. The dockets move very rapidly. Most of the time, people aren't scheduled for their first master until a few months after their NTA is filed with the court. So they're already about 3 or 4 months in by the time that they are read their rights in a group advisal setting. And then at the second master, which is usually scheduled within a few weeks or a month after the first, they're advised that they have to have their applications in by the third master, or they will be ordered removed and they will have abandoned their opportunity to request asylum in the United States. So people are often left with only like a month to find counsel and to get these applications prepared. Additionally, preparing these applications is very difficult in family unit cases. You're usually dealing with a lot of trauma, a lot of meeting and building trust with your client, like in every asylum case, but you have a much shorter timeline. And you have a much shorter timeline to collect evidence. So all of this really impacts the approval rates within family unit cases on the FAMU docket, but additionally impacts access to counsel. The family unit docket is an absolute disaster from an administrative standpoint. Cases are moved around regularly by the court without consultation with counsel. And that makes it really difficult for counsel to plan on when things are due or when hearings will be heard. And it has resulted really in a lot of people not wanting to take family unit cases because of the challenges the roadblocks the court puts up to prevent competent representation. Which means a large portion of the people in this process are going forward without access to counsel. Additionally, the vast majority of family units on the FAMU docket are Central American families, and so they face the additional issues in immigration court of the war on asylum from Central America and gender-based and gang-based asylum claims. And as Elise will discuss in a few minutes, we've seen a lot of attacks on case law that would make it harder for people to win asylum claims here. And so in many parts of the country, you'll see judges actually pre-termitting Central American asylum claims on the family unit docket, stating that if it's gang-based or domestic violence-based, it doesn't qualify for asylum, and so they won't hear it at all. You also have a big problem on the family unit docket that because of the speed in which the docket works, court isn't able to get the notice to people in time if things change, if their hearing date change or their hearing time changes, or if they are suddenly required to submit their applications earlier than they originally were ordered, which has happened in a lot of these cases. And respondents aren't able to get their changes of address filed and actually changed within the immigration court system in a timely way, meaning that they are often ordered removed in absentia, but through no fault of their own. Like they have tried to change their address and the immigration court just isn't able to get to them in a timely manner, and so they end up sending service documents and notices of hearing to the wrong address, and people miss their hearings. Much like in 2014 under the Obama administration, a lot of these in absentia orders are being challenged due to lack of notice. Many people, close to 100% of people, are successful in reopening their cases if they have access to an attorney, which most people don't. So the family unit docket has been a really, really big challenge. It's the priority for the administration right now and for the immigration courts. And so what we're seeing most recently is that detained judges are actually being assigned to hear family unit cases so that family unit cases can be heard basically every day of the week. What we're hearing from unrepresented people through different nonprofit organizations, including my own, is that when they go in without an attorney for their asylum hearing, they're basically asked like 2 or 3 questions about what's on their asylum application, which most of them prepare without counsel, and then they're told they don't qualify for asylum based on those facts. They're not asked follow-up questions, and they're not actually given a real asylum hearing, and then they are summarily ordered removed. The second challenge comes that with the fact that the family unit docket presents unique due process and equal protection challenges that have to be preserved at the lower level in order to bring them on appeal. Not only do most people not have counsel to assert those arguments and protect their due process rights to argue on appeal, but most people don't have access to counsel for appeal either. And so the court is basically violating their constitutional rights left and right on this docket without any, with impunity, complete impunity, because most cases aren't appealed. And as we'll talk about later, that's one of the goals that my organization has, is to facilitate appeals more easily amongst pro se people, and also to find attorneys to represent them in those, because that's the only way to hold the immigration judges accountable for their misdeeds on the family unit docket. So yeah, that's the family unit docket in a nutshell. And I think I'm passing it back to Elise now, maybe.
All right, so again, kind of if you can make your way through this entire just barrage of obstacles that have been placed in front of you to get into the actual courts and to apply for asylum, and you're now eligible for asylum, you get to deal with the actual law, which we've seen a number of changes being made to that has made things very, very tricky to deal with. So before we get into some of the case law, we're going to talk a little bit about how the case law has become what it is, and that is through a very unique tool called Attorney General Certification or Review by Certification. This will speak on this graphic in a bit, but this tool is one that is not new to the Trump administration. As you can, as with many of these things that are being in place, the Public Health Service Act 1944, these are things that are on the books, have been on the books, and have been exploited by this administration and used in new ways. And so that's something to kind of keep in mind too, is that these are kind of pieces of the law and pieces of our history that are now being kind of unearthed, and we're seeing them kind of wielded in a way that we didn't expect. So that being said, the certification by review tool, it's one that is allowed in part by the kind of unique structure of the immigration courts, which was alluded to previously. So EOR is housed under the executive branch, not the judicial branch, which means that it's an entity under the Department of Justice, which is then overseen by the Attorney General, who is obviously appointed by the president. So it's a very political appointment, and particularly in these times when we've had very vocalized anti-immigrant attorney generals, you can see how dangerous that is. The authority is actually enshrined in the INA, that the Attorney General is authorized to determine what would be necessary to carry out his duties for immigration. So it's built into the law, and it allows the Attorney General to essentially take decisions that have been made and then rewrite them to establish binding precedent, essentially rewriting the law on for immigration, so as long as it can be one that furthers his duties under the INA. So it's been used frequently by the Trump administration in comparison to previous attorneys general. So taking a look at this graphic, you can see that William Barr, who was under the first H.W. Bush, getting our second iteration of him, he didn't use this at all in his first tenure. And then Clinton, Janet Reno used it once out of the 94 months that she was in office. And then you get to George W. Bush, who we saw a total of 16 certifications in the 8 years that he was in office. This was the largest increase of certifications that had been seen since the 1950s and was seen to be kind of a very big deal. Then you get to the Obama administration with Eric Holder, Loretta Lynch, and there were 4 total made in the entirety of those 8 years. Now comparing, you have Jeff Sessions, who came in, and from January 1st of 2018 to October of 2018, he certified 8 decisions alone to himself. So he certified decisions at a rate of 1 for every 3 months, which was just an incredible and rapid usage of this tool to kind of rewrite how he saw the law should be. Whitaker, when he was in office and occupied this space, he certified 2 decisions to himself, and final decisions were not necessarily issued on those, so they were basically just waiting for Attorney General Barr to come in and put his own stamp on them. There are a number of decisions that have come out using this that have made some huge impacts on how the law is adjudicated. And we're just going to talk about 2 of them mainly. Though I will add that Jeff Sessions has used this to kind of gut how immigration judges are able to do their jobs. So for example, in matter of Castro-Tum, he severely restricted the ability of judges to actually administratively close cases. So if, for example, you have a case that you're pursuing a collateral relief through USCIS, and you need to kind of close your case before the court so that you can do that, the judges no longer have that ability to actually close it, and they have to sometimes go through with the actual case. just today, there was a report that DHS in Minnesota, I believe, was going to recalendar all of these cases that had previously been closed, which now means that you have a huge backlog of cases to be addressed. And it now means that people don't necessarily have the ability to pursue that collateral relief, and they may now have to go through the process of being ordered removed and now fighting it on appeals, which is a very, very scary and time-consuming process, and one that severely limits your protections from actually being removed. So the caveat to this, though, is that a lot of these cases are still being challenged. They're still being challenged in federal court and argued over. And so there's not necessarily a final word on many of them, but while they are in place and while they are being challenged, they are affecting thousands of people, and they are restricting immigration judges and attorneys on how we fight these cases. So one of the major cases that came down from Jeff Sessions was matter of AB. This went back and forth for a few different iterations. There's some interim decisions, but ultimately it came down with its final iteration in March of 2018. And it did two main things. So what it did is much of the decision is actually talking about Sessions' belief in the broad usage of certification power. And then it also attempts to limit the definition of a particular social group. So to that first point, Sessions argues that he can review cases, as the Attorney General, he can review cases that aren't currently pending before the BIA and in which there's not been a final ruling. So essentially he's saying that he can pick whatever case he wants and then use it as a platform to create and rewrite immigration law, which is an incredibly scary thing to have in the hands of one figure. The second thing that this case attempted to do is that it attempted to define what a particular social group is and how one can show that they were persecuted on account of their membership in that group. So to back up slightly, a PSG is a protected characteristic recognized by the INA as a basis for relief, in addition to race, religion, nationality, and political opinion. You can consider a particular social group is helpful for example, members of LGBTQ groups, people who are not necessarily encompassed specifically in the INA, but who fit perfectly within this definition and who are seeking protection based upon the persecution they experience because of their membership in that group. So it is a very important aspect of the law. So what Sessions attempts to do, though, in AB is he basically said that persons who have been victimized by so-called private violence, i.e. gang violence and domestic violence, are not members of a group. And so they should not be able to get asylum because of that violence. And ultimately, as written, the decision kind of guts precedent, years of precedent, years of understanding that, in fact, domestic violence does qualify somebody for a basis of relief. Now, again, it does not. This decision itself does not foreclose the possibility that people can't get relief. It's important to consider that many of this language is in dicta, and the holding is actually very, very narrow, but it's dicta that's being wielded very regularly to kind of debase these claims that are unfortunately very common. And it's a very scary thing to have in the hands of somebody who is a politically appointed figure, and somebody who is one who's vocally anti-immigrant, to have him be given this power to just gut years of protections for people fleeing violence and persecution. Kind of fast forwarding to Barr, the majorly disruptive decision would say that he issued was issued in July of 2019 when he came out with a matter of LEA. And again, it focuses on particular social groups. So again, who can actually qualify for asylum is at the heart of these decisions. And what it does is it tries to get rid of family-based groups. So if your father is targeted, your father is, subject to persecution, you are no longer able to say that you would also be subject to persecution based upon your membership or based upon being in the same family as your father. And so ultimately in practice, what it means is that this kind of group that we were seeing for family members is off the table, and now having to come up with independent applications and independent claims many times for children and wives and spouses, partners, who previously were able to seek relief under this LEA caveat. Most 8 of the circuit courts have recognized in published decisions that family-based groups are acceptable. And so again, what we're seeing is that this is an attempt to gut years of precedent and years of accepted practices and mandates in asylum law, and to kind of just call into question the reasoning and the thinking behind that. Again, it's all in dicta, but it's very, I mean, it's very persuasive, influential dicta that still has to be kind of battled against. So again, these decisions are subject to litigation. They're not necessarily the final word, but they are being implemented, and they have tremendous impact on how the law is actually affecting people who are fleeing violence. So if you can imagine getting to this stage in your case, you fought, you've physically gotten through all of these obstacles, and now you have to deal with the law. This is an aspect that is incredibly difficult for seasoned practitioners to deal with, and it is trying to, it's making everyone's head spin. So you can imagine how much more complicated it is for somebody who is unrepresented and does not understand the law. And who is just completely unfamiliar with the system, and then also dealing with the trauma of their persecution. And so that, I think, kind of leads into a little bit of the underlying nugget of this presentation, kind of woven throughout, is the importance of access to representation. And I would make the plug that people who are unrepresented have a significantly lower chance of winning their claims, even despite the merits of those actual claims, versus people who are represented for, as you can see, the myriad number of obstacles that are put in their way. And so with that, I think it's turning back to Natalie. Yeah, there we go.
Well, thank you, everyone. And that was so informative. Thank you to my co-presenters as well. Really, part of our goal in hosting this webinar today is also to not only just shock you with the horrors of what's going on. It's definitely a lot to take in, but at the same time, it's important to know that there are asylum seekers here in Colorado. Many of them are in the Denver metro area, but across the state, who are still fighting their cases, and they're very much in need of support. And many of those people have already traversed a lot of those obstacles that we've already spoken about, and are now at the point where it's crucial that they have support through the rest of their process. And so I want to give an opportunity for each one of the organizations here today with me to speak a little bit about how to contact them to get involved. Each one of us offers opportunities for volunteers. And I can speak very briefly about Rocky Mountain Immigrant Advocacy Network, and our contact is right there. We have 2 email addresses. One I will be answering, and Colleen will be answering the other one. But we are looking for attorney volunteers willing to take pro bono cases for families and children and people who are in immigration detention. And really our highest need is support for asylum seekers, both with the full merits case, taking on the full asylum case, and or helping them get released from immigration detention so that they can have a better chance of winning their case and fighting their case closer to their family or other supports in other parts of the country. If you're interested in getting involved with us, please reach out. There's more information on our website, remain.org. And also we will take volunteers that are language volunteers who are interested in helping with interpretation or translation. So if you are bilingual or multilingual, please contact us as well. And we do take law student interns as well as MSW student interns. So I will turn it now to Elise.
Yeah, so at the IRC, we have kind of a bifurcated program, and with this, we're hoping to find some pro bono attorneys, anyone with legal background who can support our Survivors of Torture program. This program is designed to help non-detained persons who are seeking status, who have been determined to have survived torture in their origin country. We provide clinical case management for them, and then also help them through their legal case. we we do both affirmative and defensive cases. So we kind of are all over the map as far as the types of relief and the types of forums that we work in. And we provide mentoring and training for those pro bono attorneys so that you're not just alone and kind of shipwrecked with an asylee seeking status. So my contact information is there, as well as the organization's contact information. And so feel free to reach out if you are interested or know anybody who might be interested, and we would love to work with you. I think, Christina, you're
okay.
up.
All right. At the Colorado Asylum Center, we're working with some very specific populations as well, just based on capacity. We are focused on families in the family unit docket. So we provide monthly workshops to help people fill out asylum applications on the family unit docket. We always need volunteers for that. As I mentioned previously, if people don't get their applications in by the 3rd master calendar hearing, they're ordered removed and they don't have the opportunity to apply for asylum anymore. And so that's what we're trying to avoid with these workshops, is just to keep people in the process so that then we can help them on the back end with appellate work. So we are also offering starting this summer, pro se appeal workshops as part of our I-589 clinics to help people appeal and articulate some of the issues that are happening on the family unit docket in their appeals. We also do a court watch program that a lot of students have participated in. We have court watch documents where we ask people, members of the community, lawyers, law students, non-law students, to go to court, specifically to FAMU dockets or detained dockets, and to take notes on things we are collecting data on, violations of existing case law, violations of people's due process rights, summary removals for not getting an asylum application in on time, and then to report that back to us with the hopes that we'll be able to use that down the road for some impact litigation on this docket specifically. We're also expanding to help LGBTQ asylum seekers starting this summer in our workshops. So we'll be taking referral for those, and we will need additional volunteers to help with that population. And then we're also expanding to take on some of the MPP appeals. So while we're not recruiting people to go down to the border right now and take on cases, there are a ton of people stuck in Mexico who do need help with pro bono appeals, and we'll be placing the family unit case appeals with volunteers as well. So if you're interested in doing any of that work, please let me know. You can reach me at the email address shown on the screen. We also have a Facebook page, Colorado Asylum Center, and you can message me or leave a comment there. We are always looking for interns as well. We need a lot of administrative help. So if any students are on the call who want to help, please get in touch.
Great. Well, if you have any questions, you can put them in the Q&A box below. Emily here, oh, I think she may have signed off, had her hand raised. I was going to try to unmute her for a moment. Oh, now it looks like she had. There we go. Emily, can you hear us?
Yes. Hi, guys. So I was wondering, I have quite a few friends in law school, a bunch of 1Ls who are looking for jobs at the moment due to, Corona was kind of like the peak hiring season, but many of them don't speak Spanish. So could you all speak to the types of work that's available for non-Spanish speakers that I could refer my friends to?
I can go on that. So our clients come from all over the world. We have a variety of countries represented in our caseload, as well as a variety of languages. And so speaking Spanish is not a prerequisite for working with us. We partner with interpreters who can provide those services. So that is not something that needs to be a barrier if you're interested in working with us.
And I can go ahead and speak for Romain in terms of opportunities for pro bono attorneys to take cases. You definitely do not need to speak Spanish, even though a large population of the clients we serve, both in detention and non-detained, do speak Spanish, but we do work with volunteer interpreters and translators. I would say in terms of students looking for internships, it is usually ideal to have proficiency in Spanish, especially with our children's program, because the vast majority of the clients we serve are monolingual Spanish speakers. But that's a little different in our detention program. And so I would definitely say to reach out and look for opportunities. But that generally, if you're trying to intern with us or be hired by us in the future, Spanish language is really important. If anyone has questions about immersion programs or even virtual programs that are happening right now, please email me, because I love sharing those resources. And it's something that I really dedicated time to in law school. So I can talk to you about that as well.
And for the Colorado Asylum Center, we have plenty of work for non-Spanish speakers. Generally, to participate in the I-589 asylum application clinics, it's helpful to speak Spanish. If you're really interested in that and you don't speak Spanish, you can reach out to me. We do have Spanish-speaking volunteers who don't feel comfortable filling out asylum applications, who would be happy to work as an interpreter for you. But for the student activities and other legal activities, such as taking cases and appeals, we can definitely facilitate interpretation for you.
Great. So we just got a question in the Q&A. Feel free to write additional questions in the box below, but this one is specifically for Christina. They want to know, with COVID-19, how has the Colorado Asylum Center been modifying your asylum workshops? And have virtual workshops been an alternative, or are you hoping to do modified in-person workshops in the summer?
That almost feels like a plugged, prepared question that I did not do, I promise. We are doing virtual clinics right now for the Colorado Asylum Center. We have been running those clinics virtually since our March clinic was scheduled. So March, April, May, and then coming in June will be virtual clinics. We will be trying to implement socially distanced clinics over the summer months in July and August, but with the option to continue virtual volunteering if you feel more comfortable with that. So as the rest of the world is adapting to COVID, we are too. It's really important that we continue to serve the populations that we serve so that they're not ordered removed in court. So we are doing everything possible to make this safe so that people can continue volunteering. If you're interested in volunteering remotely, please don't hesitate to reach out to me. How that works is I come and meet with people in person to sign them up for the volunteer workshop, and then I will just place families with you via telephone and send you all of their information so that you can make contact, and we'll give you a deadline to have things completed by for review and printing and mailing to each individual family. And as we learn more about what works and doesn't work, we will continue to adapt this. So, thanks for your patience ahead of time, but yes, we still have plenty of volunteer opportunities for you.
I can say that I volunteered with Christina's organization remotely, and it was very smooth and efficient, and it was a great experience. So I definitely recommend that. And even just wanting to kind of give some context to the ways in which sometimes the same families who might be on FAMU are being served by one organization, by the Colorado Asylum Center, and then might be coming to RMIAN, and we're doing a full intake and either being able to match them with an attorney, or sometimes we discover that they're survivors of torture and they're a better fit for the IRC. And Elise is then helping match them with pro bono counsel or providing counsel through the organization. So we really do work together to really promote better case outcomes and support and representation access for some of the same population. So that's why I just wanted to explain that, because sometimes volunteering with an organization is actually part of this big picture of support that we have here, thankfully provided by these three organizations in Colorado.
Well, there's another question. This is a tough one, so maybe Elise or Christina. If the administration changes next year, will it be possible to walk back these policies, and what would be the avenue for that? Who wants to take that one?
All right, go for it.
I mean, we could both share opinions. We might have different opinions on this panel, which is not unheard of. So mine is very pessimistic in that I think it will be really challenging. I don't think that if we have a new administration, I do think some of these policies will change. And because a lot of them were done by executive order, a lot of them can be changed easily by an incoming administration. The issue is going to be what that looks like on a practical level, right? So if the incoming administration were to end MPP, for instance, you have like 60,000 people, maybe a little less now, given all of the horrific conditions they've had to face while waiting in Mexico. But how do you get those people processed into the United States? And how do you deal with the court backlog that that's going to create? And how do you deal with the transfer of all those cases from the border to courts around the country? So I think we're going to see a lot of challenges in undoing some of this. And unfortunately, a lot of what has been done can't be undone because the harm has passed. So the people who have been disappeared in Mexico, thousands of families, like, you can't undo that. And so that's what's so dangerous about this administration, is that a lot of the harm is really long lasting. The people who have been sent back to Central America under the asylum cooperative agreements, I mean, those people could be in danger right now. They likely are. And they're likely going to continue facing danger over the next few months. Who knows what will happen at the end of that timeline? Who knows if they'll be able to make their way to the United States again to try to ask for some sort of real protection from the harm they fear. So it's not quite as easy as just walking back the policies that are in place. Now, could the court stop prioritizing family units? Sure, they've done that before. This is not the first time they've targeted Central American asylum seekers. It also happened in 2014 under the Obama administration, and they figured out it wasn't working, and so they stopped doing it, and they moved their attention on to some other group they wanted to focus on. I think the real issue here is not will there be a will, it's will there be a way, and how long will that implementation take? I don't know, Elise, if you have a different opinion about that.
Oh, at least I think we're having trouble hearing you. You're unmuted, but it might be your sound.
Is that better? Okay, sorry. I was just gonna say I would largely agree with that in that the damage has been done. Even if things are able to walk back, and these policies are able to go away or things like that, and we find a practical way forward, the other piece of it is that our reputation has been damaged. And so people may not want to be coming here. People may be trying to seek help elsewhere. And so these are long lasting things that are going to affect these asylum law for a very, very long time. We've already lost our standing as the #1 acceptor of asylees and refugees. Canada has now surpassed us, and that was a position that we held for years. So I would love to believe that we can just snap our fingers and everything will go back. But let's also consider too that the stage has been building for a very long time to get to this point in this administration where they were able to wield all of these things. We're going to need a lot of work from Congress to be able to get some longer lasting things in place to kind of not have this easy flip-flop back and forth where AGs can just certify decisions and say what they want, and then it's going to flip back to the next AG. So I would love to just say we can snap our fingers, but ultimately I think there is just a lot of really hard work that's going to have to go in so that things are going to be preserved for the better.
I think it's also important to note that what we're seeing in immigration court is not the only piece of this that could be like addressed by a new administration. We didn't talk about the Board of Immigration Appeals, which is the appellate body that hears immigration cases, but it is being stacked right now by the Trump administration with judges who have 94% denial rates for asylum or higher, and they are just appointing person after person after person who've spent their entire careers attacking asylum seekers. So that is something that an incoming administration could change, and that would make a big difference. Also, as Elise mentioned, the certification and referral process, that is something that we really need to end, but specifically in the hands of like racist, xenophobic, white supremacists has caused a lot of damage. And so like not having those people in charge would be very helpful. And I don't want to ignore that like there will be people who are approaching us for protection in the future who won't have to come into contact with all of these obstacles if we have a new administration. Even if we can't fix it for all of the people who have been harmed, there are still going to be people in the future, and we can avoid causing more harm to them. And so go vote.
Yeah.
Great. All right, we got a few more questions. So this one specifically for Christina. In the remote family workshops, do you help people draft declarations for the asylum applications, or do you have volunteers doing that separately?
We do not draft declarations. In fact, we actually keep the applications that we fill out with people very simple, a very general summary of the fear that they have, and we state on the application that it is a summary. In my private practice, I actually do not submit declarations as a matter of course in asylum cases. I have only seen them used for harm, never for good. And so we just don't do that. But in the asylum clinic, it's even more vital that we keep things very general, because we are only meeting with people for approximately an hour to help them get a skeletal application before the court so that they can have their day in court and explain in detail what it is that they fear returning to. It would be ineffective at best to meet with someone for an hour, only get into like the very superficial parts of their case, and then include a ton of details about that in their application. So our goal is just skeletal application in front of the judge to keep them in the process, and then with the hopes that they'll either find counsel or be placed with counsel or have their own opportunity to describe in detail what has happened to them and what they fear in their final hearing. That doesn't always happen, but it is better than nothing, and it is better than causing credibility issues for them later, since we're not going to represent them in court.
I just wanted to let you know, Colleen, that we have under a minute, so maybe we can take one more question.
Sure. There's a few more here, but I'll just go with the first one. So a few of us talked about training sessions for attorneys. Do these trainings teach attorneys what specific keywords or facts or case law to put in the asylum applications to hopefully increase the chances that they will be granted? And can an attorney with no background in immigration law still be helpful to our organizations? So Natalie, why don't you answer for RMIAN?
Excited to answer that question. Yes, and I know Elise mentioned this as well, but all three of our organizations provide training and mentorship in different ways, depending on the type of task that or case the attorney is taking on. If you were to want to volunteer and take a case with RMIAN, the vast majority of our pro bono attorneys have never taken an asylum case, or have maybe done a different sort of asylum or a different sort of immigration case and are interested in trying an asylum case with us. We provide mentoring both through an amazing panel of mentors that are local immigration practitioners, as well as through the Immigration Justice Campaign if it's a detained case. And we do provide regular trainings and CLEs, and also have a plethora of materials available to pro bono attorneys that they can access for sample briefs or templates, as well as trainings on how to fill out the 589 and other recorded trainings that we've done in the past. So I'll let Elise and Christina talk about their organization's training structures.
Yeah, so we also provide training and mentoring throughout the process. We do our mentoring in-house at this point, and so we maintain very close contact with the cases. We do a lot of work up front to vet the cases and to kind of get the best idea of the claim. And then once we hand it off to the pro bono attorney, you're not alone. We are there to help provide resources and to strategize and to kind of help walk you through what it looks like. So we, again, most of our attorneys do not have immigration experience. And so we are there as resources and guides to kind of help you work with these clients and get their cases approved. Christina, do you want the last word on that?
Yeah, we also take attorneys who do not have any immigration experience. All of our mentoring and training is provided in-house as well, depending on the level of help that the individual attorney needs. So I'm actually super willing to like go as far as sitting second chair with you in your first asylum hearing. I know it's really scary to think about trying like a death penalty case in immigration court, especially if this is your first introduction to it. But we will provide you with all of the materials and support that you need in-house at this point. All of our board members are mentors on our cases that attorneys take, and on our asylum clinics for volunteers who come in. We provide a training, and then you get direct mentorship from all of our board members as well, who are immigration attorneys or who have taken volunteer cases and are now mentoring other attorneys who are not immigration attorneys to take volunteer cases. So you'll have a ton of support, and we really would love to have you. Honestly, immigration attorneys are spread really thin right now, so we need as much help across the board from non-immigration attorneys as possible. And thank you all for coming.
Yes.
Okay, well, thank you so much. I'm so sorry we didn't get to every question, but we're gonna go ahead and wrap up to stick to our time. This is recorded, so we might make it available in the future, and we also will follow up with anyone as soon as we hear about CLE credits. But thank you so much, and please do take a screenshot or a photo of our contacts right now on the screen. We would love to be in touch and talk with you more. Thank you so much for your interest today and for your support. All of you are, I'm sure, doing in the community, supporting immigrants, refugees, and asylum seekers in different ways. We appreciate your time, and thank you.
Yes, thank you.
Thank you.